On the Spot with Lux Live, talking property, business and success in real estate.
Thank you, ladies, for joining. This is our second take, so this podcast must go really beautifully because we did one and it failed with the sound. So today we're expecting wonders. So we're going to talk about rentals. We're going to talk about landlords and tenants, and Bianca, your experience, and just guiding us through this very difficult path of doing the right thing when sometimes maybe frustrations are so high on both sides that the temptation to do the wrong thing is very high. And I just want to, start by, just hearing what is your experience in terms of, what do you do for a living, so you can show people that you probably know what you're talking about. And then we'll give you some case studies because we've done hundreds. I don't want to say thousands because I haven't counted how many, but we definitely way above 1,000 in terms of rentals. And we have had some hair-raising moments and we've had some stress in our lives. And as tenants and as landlords and servicing landlords and tenants. So I just want to first of all introduce yourself and tell us, what you do. And then we'll throw you some case studies, Lubona and I.
Perfect.
Lubona's ready.
Very ready.
That sounds like fun. Thanks for having me again. It's a great pleasure to be here and to walk this path with you guys. So my name is Bianca Blackbeard and I'm a senior associate at SSLR Incorporated Attorneys. We are the property law firm, which we are very proud of. And we're here to assist the industry, especially with the rentals. Like you mentioned, it is quite a interesting field of law. And and it's a personal field. A lot of things, affects people personally, the tenants and the landlords both. And it unfortunately comes sometimes down to that you do the wrong thing in that moment. So let's have a chat and see how we can help each other and the landlords and the tenants out there.
You guys wrote a lot of the legal framework for TPN, correct?
Yes. The TPN residential lease was written by our firm, drafted by our firm, and it's obviously updated as legislation changes or whatever updates needs to be done. And then we're also involved with a lot of training in the industry as well. The estate agents trainings, LSSA training. So there's a lot of trainings that we do assist with. And we also believe, obviously, if you train and you have proper expertise in a field, you feel more secure and you feel more confident in your dealings every day. And I think that adds value to the industry overall.
Yeah. Look, you've done training for our company as well. No amount of training also can equip you with every single situation that can arise. So I think also doing a lot of the cases and, us doing leases and just encountering issues on a daily basis, having someone like you guys, to gain the knowledge or watch your YouTube channel as well and, just learn what happens. But literally every day, we've now been doing it for how many years? And this week we have a new experience.
We had a new experience just yesterday. So we just want to find out, it happened to us now, but it also happened in South Downs a few weeks ago.
A few months ago, when the power station exploded.
Yes. So what happens when Eskom or any of the service providers fail to provide electricity in a place, and then in our case, what happened was our tenant didn't have power for 2 weeks. Then he moved his family to an Airbnb. So now when it's time to pay rent, he tells us he needs compensation, obviously, for the inconvenience. He's looking at the takeaways he was buying for his kids, and also the accommodation. So how would you say we tackle that?
Yeah, it's always a difficult situation because you have to distinguish what is within the landlord's power. No pun intended in this instance, but what is within the landlord's power? What can he do? What should he have done? Now, if you're dealing with a breakdown of a station, for instance, there's nothing that he could have done, and that tenant is not alone in the circumstances. It's
Yeah.
not like only his house was down, it's the whole area, for instance. So obviously, if it is being reported to the relevant municipality timeously, that's the first thing. So any tenant landlord, if you realize there's a power failure in your area, you have an obligation to report that to the relevant municipality, which would then in South Downs be Tshwane, I would assume. And then obviously you can't delay that. You can't think your neighbor is going to do that. And rely on someone else to do that, because you need to advise the municipality, listen, there's a problem and they need to attend. If they then take
Long.
an X amount
In
of
this
time.
case, they took long. So
Exactly. So you must also see, I mean, if there's a big area outage, they only also have so many people that can attend, and depending on what happened to the power station, I mean, if it literally exploded, it's not an overnight fix. But if there is a delay on either party side, say for instance the tenant realized the power station or the power was off, but he did nothing for 3 days, assuming his neighbor would. Neighbor also did nothing, assuming his neighbor would. Then that delay was caused by these parties themselves. So then you can't hold anyone liable because you were negligent in not acting on this situation accordingly. If you report it immediately or as soon as you are able to, and it's a situation where the municipality doesn't get back to you, or they like to send you these kind of updates that artisan is being appointed or something to that effect. I mean, then you also need you have to work within their timelines. But when it becomes a situation of a week or a month without feedback, then there's definitely some sort of negligence on the side of the municipality. The problem is how to prove that. And especially if it's going to be a big area outage. If it's just your box in the street and they need to have one person attend to it and switch it on,
and
that's
they
a different
took long.
story. That's a different story. But if you now attend to a 100 square meters of area or kilometers of area, I mean, that's a more difficult situation. And depending on what happened to the actual, the box that exploded or the trip that was recorded. So in this instance, there's nothing that the landlord could have done otherwise. It's not like he cut off the power because somebody didn't pay.
But
it was
now
a
they're claiming part of the rent.
He's not entitled to do that. It's not within the landlord's power. It's not that the landlord can do anything to Eskom or to the municipality unless he didn't provide the fact that it was off within a reasonable time. But if that was provided to the municipality within a reasonable time, it's out of the landlord's hands. He can't do anything more than that to assist the tenant. And again, same situation. It's the whole area that's affected. It's not just you. The fact that you chose to buy takeaways and not get your gas stove from the garage, your camping stove from the garage, that's your decision. And that's a problem. It's the same with load shedding.
Yeah.
If your load shedding is on for 6 hours at a day, you can't claim that your meat defrosted because you knew it's going to be off for 6 hours. You need to make alternative plans. You need to mitigate your risk as well.
Okay, so in this case, it was the one we're dealing with now, currently, the landlord even hired a generator for
that's
the tenant.
Above and beyond.
So that's what I wanted to find out. Was she supposed to do that, or
that's very nice? And
but
it's
she's
really
not obliged.
It's not obliged, no, because the landlord's obligation is to make sure that there is a power connection.
Okay.
So he can't cut the power himself. If there's an external factor that affects that power connection that has nothing to do with him or his actions, he's not obliged to get a generator. It's going to be the same if you're the owner of a property. I mean, if you know the power is going to be off for 6 days, then you make a plan. You don't just leave your refrigerator, for instance.
Yeah.
Even if you're not the tenant, forget the rental part for the moment.
Yeah.
I mean, if you're going to leave your fridge like that, and then after a week claim from your insurance is also going to tell you, listen, but what did you do? Did you get your Coleman closer and buy some ice or whatever the case may be? So I think the expectations needs to be managed. And I
Yeah.
think tenants' expectations, especially in these circumstances, if it is something out of the landlord's control, power failures is out of his control. It's not like he disconnected the power and he had an effect or a reason behind it. There is power to the property, just not currently because of an
Yeah.
external factor.
Okay.
So
yeah.
I think managing expectations is going to be a big thing. If the landlord, in your instance, did provide the generator, I mean,
generator.
that's
That's
really
it, eh?
above and beyond. There's no obligation on them to actually be doing that.
Okay. All right.
So this is where also right and wrong starts playing a part. And you guys have written in your lease that the tenant cannot withhold any rent for reason whatsoever, because two wrongs don't make a right. For example, if they have a grudge against the landlord for a reason.
Yeah.
And what we're finding, and it happens a lot, is exactly that. You know, a tenant would say, well, I'm now going to reduce the rent, or I'm not going to pay until you resolve. And I mean, now in this case, there was no power, but let's say it happens often where they disagree with the utility bill. Eskom charged me too much, the water is too much. Until the landlord resolves this, I'm not paying it. How does one deal with this, and what is the expectation on both parties? Because you often find both parties are maybe uninformed, and the landlord would also then maybe get all flustered and say, oh, I need to resolve this issue. My take on this is always that if you own a property or if you rent a property, if Eskom reads estimates and then one day hits, we're dealing with the case now, 78,000 Rand bill because Eskom for 2 years didn't go and read on the property. So if that happens, our letter L has just come down, but we did.
It's fine.
It's just bringing attention.
Yeah.
So what do we, how do we advise that both parties read a situation like this clearly so they know whose responsibility it is? It's good, it's fine.
In our experience, a lot of the disputes actually just comes down to expectations.
Yeah.
It really does come down to what each party expects to happen or should have happened in this instance. So, I mean, yes, the municipalities are not very diligent in reading, and they might read now and then 3 months later and whatever the case may be. But there's also responsibility on you as either a landlord, as the owner of the property, or then the tenant renting the property, to actually take your own readings, which you can then submit to Eskom. I've always used this example. If you are paying off your vehicle through any financial institution and you don't get an invoice that month for your payment of the vehicle, is that vehicle free for that month?
No.
No.
It's actually a very, very good
So-
way of looking at it.
And you can take it with a Woolies account or a Vodacom account,
Yeah.
or whichever way. If
Yeah.
you don't receive a account for that month, it doesn't mean you don't have to pay that month.
Yeah.
And it's the same with the rentals and with electricity. Unless you've not been in the property for a month and didn't open a tap or put on a light, that there can't be anything. If you've lived in that property and there is water and usage of electricity, then you're liable to pay. So the fact that you didn't get an invoice didn't suddenly make it free. And I think that expectation, I don't know where it came from, that you have to have an invoice to pay.
Even for rent.
Even for rent, they don't pay. They'll
Exactly,
say,
and it's the
no, I
same
didn't
thing.
receive an invoice.
Exactly, it's the same thing.
Yeah.
And then literally, I mean, it's not like any bank on your car payment is going to say, oh, yeah, shame, you didn't get it. And then
Yeah.
they're going to either fine you or,
Yeah.
take whatever recourse they can. And it's the same thing. So that expectation really needs to be addressed overall. The fact that you didn't physically get an invoice doesn't make it free. Then there's an obligation on you. If you know you have to pay by the 1st of the month, for instance. The invoices are usually sent out by the 25th or 26th. If you don't receive it by the 26th or 27th, or even at the end of the month, then
you
you
follow
pick up
up.
the phone or email or follow up with whomever you need to get that invoice. And I think a lot of times, I don't know if it's kind of a situation where if you don't see it, it goes away type of feeling that they have. But I mean, in the real world out there is an obligation on you as a tenant to make sure that these things are done correctly and that you get the invoice. There might have been a server breakdown or whatever the reason might be, that it might be stuck in an inbox that, you don't check or whatever. But there's an obligation on you as a contracting party to follow up on this. So if you don't get your invoice by the 25th or whatever the arrangement is with the particular tenant, then you do follow up and you make sure that you do. Or if you know your rent is 8,000 Rand or 10,000 Rand a month, then you pay that.
Yeah.
Even though you haven't received that invoice. You can rather then say, listen, okay, I paid too little or I paid too much or whatever the case may be, and you can, on an administrative side, sort that out. But the fact that you didn't receive an invoice doesn't make it free for now. And that's really something that the tenants must understand. There is an obligation on them. They signed a contract. They agreed to pay. And there remains obligation on them to pay. So really, there is no excuse to say, I haven't received the invoice, I don't know what to pay. And the same with the prepaid electricity obviously makes it much easier. Because they buy the units and they put it in and they know what they use. Water, you can take readings. There's a water meter at every property. So you can even, set an alarm or set a reminder once a month, you take a reading. And then you have some recourse, because the difficulty comes in if Tshwane now comes with a bill of 70,000 Rand and you don't agree, how are you going to disprove it?
Yeah.
You
can't.
So there is an obligation and a responsibility on every tenant and landlord, or if your mandate stretches so far, to go have a reading at least once a month to make sure that these types of expectations and disputes that might arise are minimized in this regard.
Yeah.
Okay, it looks like I've got a lot of rental problems. So here's another case study.
You've been preparing all night for this.
Yeah. No, so there's this tenant that we've been having for a year, and then they just renewed for, I think, 8 months more. Yeah, just below a year. So what happened was she reported, we have a system that we use for maintenance, right? So when they report, our rental manager will obviously communicate with the landlord, and then, but what happens is sometimes the landlords take long to approve the quotations. Then there will be a period of time before that that problem is actually attended to. So what happened was, I think this lady logged about 4 problems. They were attended to, but not like immediately. So this landlord is one of those that take their time to respond. Then she reported a lock to say there was something wrong with the lock. And the lock, just a day before someone went to fix, she had a break-in. And she's taken the landlord, obviously, to the rental tribunal. So how do we deal with that?
Yeah, you see, that's also a difficult thing, because my reasonable and your reasonable might not be the same thing. And again, so expectations.
Do we have a period?
In this case, I think it was 5 days. 5, 6 days?
5, 6 days.
Yeah.
And
that's gonna play a role. And obviously what the problem is that was reported. I mean, if it's a tile lifting, for instance, it's not an immediate danger. It's not gonna cause you any harm. So you're gonna have to look at what the item is and what can be reasonably expected for this repair to be done. I mean, if you have to get a whole team in and it's going to be a day's work, whatever the case may be, then you have that reasonable is also different to buying a item from builders and, just fixing it. So you're going to have to look at the actual problem and what would be a reasonable time. If it's a leak in the roof, for instance, and it's rain season,
obviously it's immediate. Yes,
then it's immediate and you need to make a plan quickly. If it's not rain season, and there's no real direct harm, yes, there's a leak in the roof, but it's not going to affect you within a week or two, and you need contractors and, special approvals or whatever the case may be. That's a different story. With the lock situation, I assume then, did they get in through this door?
No one knows because the neighbor was also broken into.
Yes,
You
the
see.
neighbor was broken.
So, and
Yeah.
that's also a problem because they might not even have gone through that door. I mean, it's not like criminals are not known for checking whether a door is locked or not.
Yeah.
Unless
Yeah,
you know.
they'll break the lock if
That-
it's not open.
Yeah, or they'll break a window or something. And the fact that there was another break-in, you know, it wasn't targeted to this specific tenant at all. So I think it's just coincidence that the lock wasn't working. I don't think that the lock, well, it might have prevented the burglary. We don't know.
Yeah.
But the fact that the neighbor was also broken into, I assume, on the same night
Yeah.
or the
Same night,
period,
yes.
yeah. You know, it's in all probability that it would in any event have happened. And with such a thing as a break-in, unfortunately, we do live in South Africa, so it is a thing that happens. It is a situation, you know. And I don't know, this door, was it now a front door or a back door? Where was this door situated?
Back door,
Yeah.
sliding door.
Sliding door. So, you know, there might have been something else you could have done if you really felt that, you know, there's a problem or there's something happening or whatever. Let's turn it around. If the situation was that the neighbor was broken into the day before and now you broken in, then it was a problem because there's obviously an issue now. There was a break-in, you know, the chances of it happening again is there. And then you should have acted accordingly because of what you already know happened.
Yeah.
But as this was on the same night, I mean, it might or it might not have happened in any case.
Yeah.
And because
Coincidence.
because they also don't know where they got in.
Yeah.
I mean, yes, they might have just slid the door open and gain access that way. But they were obviously already in the premises or in the property or in the complex already.
Yeah.
Now they got some gadgets. So where I'm going with this is, obviously, I'll be going to the Renter Tribunal anytime soon. I'm just waiting for them to summon me. So obviously they got some gadgets. They stole some gadgets from this tenant of ours. And you know how it goes. She will obviously want to demand, a repayment or whatever, compensation from the landlord. So do you think it's fair that the landlord is liable to pay for these stolen gadgets?
Well, you're going to have to refer to your lease because the TPN lease clearly indicates that the tenant should have insurance on his personal property that he brings onto the premises. The landlord has insurance on the actual structure.
I'm so glad we're using your lease.
Yeah,
I'm so glad, so it makes my job so much easier
I'm
in
going
explaining the situation.
I'm going to print and highlight. I'll start putting everything in my file now.
And even you can go even so far and say if
Okay.
the tenant doesn't have insurance on his property that he brings onto the property, he's in breach of contract. Because in the contract he agreed and confirmed that he will get insurance on his property. And
Case
the landlord needs insurance on the structure.
Yes.
And that makes complete sense.
Yeah.
So just have a look at this specific lease as well. But you know,
No, well,
it's gonna be the same.
Yes,
Yeah.
we'll
And then
definitely do that.
then it's going to be, you know, the same thing and say, listen, sorry, there was no negligence on the landlord. He acted within if it's 5 days, I mean, it's not like it's 3 weeks.
Yeah.
And the fact that the neighbor was broken into the same night, you couldn't have foreseen that.
Yeah.
If it had happened a day or two before, you know, then there might be, they might come back, whatever the case may be, and try again. But I mean, it's a one-night thing. It was maybe just, you know, a chance that these criminals took and they got lucky this time.
Yeah.
And like we said, we don't even know if they actually gained access through that specific door. But yeah, the tenant should have insurance on his property that he brings onto the premises.
So that would then cover, because interesting, you mentioned that, and I've never made the connection, but that would cover when there's a burst geyser. Very often, you know, the whole ceiling comes down on you,
Exactly.
and then there is a claim,
Yes.
insurance claim on that, you know,
Yeah.
which we've dealt with frequently, but sometimes you find then a tenant will say, but you know, my priceless carpet that has been with us for generations or whatever.
Yeah.
So that is where the personal insurance needs to come into play.
Yeah. And then they, on your Berskese example, obviously then the landlord gets that repaired through his insurance, that side.
Yeah.
And then any other damages that happens on the property for the tenant is through his personal insurance, yes.
Okay, and just to turn it now towards the landlord a little bit, because we saw some photos of one of our luxury homes the other day that's quite a high-end rental. It's 75,000 rand, the rentals for that home. And the tenants are diligently paying their rent. However, the entire house is now full of damp. Basically, the walls are bubbling like bubble wrap, literally. And the landlord is saying, I can't afford to fix it. But 75,000 rent is being paid every month. How do you approach a landlord who tells you they cannot afford, they expect the rent to be paid, but they cannot afford to pull their weight when it comes to maintenance?
Yeah, you see, that's also a problem. And there's also a slight distinction that you need to make in cases of mold. Because some of the mold is actually day-to-day cleaning.
This is bubbling the actual
plaster.
So it's
actually raising damp, so it's not necessarily in a bathroom or so.
No, the entire house.
You see, then it's going to come down to a structural defect.
Yes, it is definitely a structural.
And then again, depending on the insurance policy and what is covered and what's not covered, the landlord's going to have a look at his insurance policy, whether this type of repair is covered in his specific policy.
I very much doubt.
Yeah. So, and then it's going to be for his account, unfortunately. And the problem that the landlords must also realize, yes, it might not, doesn't look nice now for the moment, but the damages are going to get worse.
Yeah.
And then it's going to cost you more. So obviously, you need to make a call as a landlord then in that instance. You need to mitigate your risk as well.
Yeah.
So the tenant is always entitled to, if there's maintenance that the landlord doesn't do or doesn't adhere to in terms of his obligations, the tenant can also place the landlord on terms.
Yeah.
So the tenant can also, depending whether it's now a fixed term lease agreement or then a month to month, but let's use a fixed term lease agreement, the tenant can literally give the landlord 20 business days to attend to these repairs.
Okay.
And if he fails to do that, they can cancel the lease accordingly for breach of contract.
Okay.
If it is such an extent, that it's like affecting 3 or 4 or 5 rooms, then the parties must, get together and say, listen, we can't do everything at once. That's going to cause an inconvenience to the tenant as well. But we'll do this over a period of 6 months, for instance.
Right.
And then you just start somewhere. But the tenant is very well within his rights to place the landlord on terms if it's one of his obligations that he doesn't adhere to.
And now a different property, now we're going to flip it on to the tenant again, because often you see the one party, like in this case, the landlord refusing to do it. We have another case, another luxury property, this one 150,000 rent, massive property, and older house, so a lot of maintenance issues have arisen in the last 5 years. However, the tenant who's departing now after 5 years was highly sensitive to COVID threat, so they refused to allow any form of worker in the property for 5 years. So the property has deteriorated to a incredible level. So what is the landlord's right, again, in this respect? If the tenant is saying, I'm within my rights to not grant you access, you're not coming in. I've got a lease.
He has a lease and he should read that lease.
Yeah.
Because in that lease, it states that the landlord can request reasonable access. Now again, reasonable. My reasonable and your reasonable. But 5 years is definitely not reasonable. I mean, if it was in that year of COVID, that 2020, yes, maybe if you're now a susceptible person or whatever the case may be. But other than that, 5 years is not reasonable. And if you take your ingoing inspection and you compare it now to your outgoing inspection, and there's a huge difference, and if it deteriorates so much, properties don't deteriorate overnight.
Yeah.
Okay, there's a lot of things that a globe might fuse or a,
Yeah.
a little scratch or a thing, but
Yeah.
they don't deteriorate overnight unless, obviously, you don't maintain your part and
Yeah.
do the maintenance that you need to do. So in that instance, the tenant's going to be held liable. And the landlord will very well have a damages claim for whatever that extent of the damages will be. No reasonable court or forum or rental housing tribunal will agree that 5 years is a reasonable period for this tenant not to have done any maintenance and not to have allowed the landlord access to the property. And it's very important. And, from a property practitioner's point of view, you guys also obviously need to keep both parties happy, which places you in an extremely difficult position.
It does.
Although that the client is actually the landlord, you're dealing with personal relationships each and every day. But the problem here is that first time when you see or you realize that the tenant is not maintaining the property as he should, as per his obligations, or not allowing the landlord access to do his maintenance, whatever that might be, then we have to follow the proper recourse and procedures, which will be a letter of demand. Because in the lease agreement it states, you're going to give me access for reasonable repairs. Now, I say reasonable is 1 day, you say reasonable is 5 days. Okay, we compromise on 3 days, whatever the case may be.
In law, is there such a thing that you guys would say up to a week is reasonable, a month is unreasonable?
It's going to depend, highly dependent on what happened. What is the problem? If it's a pool in the winter that needs to be, repaired, where you in any event not going to use the pool, for instance, versus a pool in the summer where these people are going to use the pool every day type of situation, that differs. If it's painting of an outside wall, that's not harmful at this point in time, or doesn't affect the property at this point in time, then it might be that we say, listen, we're going to do it in a month's time. So it really is very dependent on what the problem is. Leaking roof in rain season, big problem. You see, so it's really very dependent on that. Interesting, we had a situation just this morning where an agent phoned me and said the property has a chimney and a fireplace. But the chimney is apparently not working, which nobody knew.
Okay.
And then when this person, because of the cold in the area, actually made a fire, the smoke went into the neighbor's property, which nobody knew. When this was reported to the landlord to say, listen, but you need to fix this chimney. This is a structural
He said, it's not my
defect.
problem.
It's
the neighbor.
But it never worked, and they shouldn't be using it. And that's not reasonable.
No, it's
If
not.
the property comes with a fireplace,
We expect it to work.
it looks like a fireplace, it
must
seems like
work.
it must work, and it's a structural thing. If it doesn't work and this fireplace is merely there for a decorative reason, then that should be disclosed. To say, this is just for looking nice, it doesn't work, it should not be used. But that should be done prior to this tenant signing the lease. Because then the tenant might have said, well, I don't want this property because I actually like a fireplace and I want a fireplace. So now, in this instance, this is going to cost the landlord quite a bit of money, but he's obligated to repair it. Whether or not he likes a fireplace is irrelevant at this point in time. It wasn't disclosed that this fireplace is no longer working. And we are now sitting with the call that we are having. So the tenant is upset, and reasonably so. So it's literally a thing that you're going to have to, it's going to be on an ad hoc basis what the item is and what needs to be done. But this fireplace, we can't repair it in the summer. When it's after the fact. You see. And again, this tenant is very well within his rights to place the landlord on terms. To tell him, listen, you have 20 business days to repair this fireplace. Otherwise, I'm cancelling the lease. And I think that is also something that the landlords need to understand. The fact that they might not have the finances at the moment is really not an excuse. If you rent out a property, yes, you pay the bond and there's certain expenses, but there is a part of that rent that you should actually bear in mind is going for maintenance. And although it's very nice to get that income, you have an obligation to make sure that if this maintenance occurs, it might occur in a month or in a year's time, but that you can cover. You can't now not repair something because you don't have the financial means. But like your property with the 75,000 Rand that's being paid, obviously everything is done perfectly. There's an expectation created that, listen, if something happens, the landlord needs to fix it. And again, reasonableness, but both parties need to understand where their obligations, start and what that entails.
So, I mean, there was a gem here. What you said is that if you look at an object and that object has a purpose, unless disclosed, that object needs to be in working condition to the purpose that it's
intended
that it
for.
is.
Yes.
Yeah.
Yes.
So whether that's a fireplace or a
Aircon
jacuzzi,
yes.
then
most
it
of
has.
the jacuzzis don't work.
Yeah.
Most of the jacuzzis
Yes, and they don't disclose.
Yeah.
Yeah.
And I mean, if I'm a particular
Underfloor heating.
exactly.
Underfloor heating, yes.
If I'm a particular tenant and I look at a property and I see a jacuzzi and that brings me to actually sign this lease, and I find out that this
It's not
doesn't work and nobody disclosed it, but that was the thing. Same with solar.
Yeah.
If solar made me rent this property, it was it was there. I saw it.
Yeah.
I
Part of
saw
the
the
package.
inverter or whatever the case
And they
may
took
be.
it.
And they took it, for instance. But I saw it. Nobody said it's going to be taken.
Yeah.
And that's why I signed the lease. That's misrepresentation.
Yeah.
Unless at that point in time the landlord says, listen, I'm going to take my solar or I'm going to take my inverter or whatever the case may be. If you were persuaded to enter into this agreement because of what was shown to you and what you saw on the day, and nothing was disclosed as to this would not be relevant to this property, I mean, then you are very much entitled to say, listen, this was a misrepresentation and I can cancel it. I'm not getting what I contracted for.
And on that note, then, with appliances, obviously properties come with the jacuzzi, they come with the pool and the pool pump, they come with the oven. And then in the period of tenancy, those things break and need maintenance. Endless issues. Who pays for what? Whose responsibility? How far does each party go?
The big thing here is you're going to have to place the tenant in the same position he was prior to this item breaking. So if he has a gas stove with 5 plates, fancy schmeg, whatever the case may be, and you want to, replace it now with a small little DeFi electrical oven, it's not the same thing.
Yeah.
It's not what he signed for. It's not what was shown to him. It's not what he agreed upon. Unless you're going to decrease the rent then.
No. I think the question is who pays for what when things break?
So the gas burner stops working, yes. And the landlord says, no, the tenant must pay because they're using it.
Yes,
not
or
me.
the fridge, the crack in the fridge, one of the tenants.
Yeah.
That is going to come down again to what happened to the item. How did it crack? Why did it crack? Did the plastic deteriorate because it's 20 years old? Or did the tenant put something down hard on it in the fridge and, or the child hanging on the door or whatever the case may be? So then you're going to have to establish what happened to the item. And the same with the stoves and the ovens. All of these items have a life expectancy.
Okay.
So the big reason or the big test here is, did the tenant do anything to shorten that life expectancy?
Okay.
All right.
Okay.
So if nothing was done to shorten that life expectancy, and life expectancy is not your life of 80 years, it's a 2-year or a 5-year. Even in the kitchens, I have an expert in a kitchen that I usually, phone as a phone your friend type of thing. A lifetime of a kitchen is 15 years.
Kitchen cabinetry. Okay.
Yeah. So that's 15 years. So now, I mean, you think it's a lifetime guarantee, but it's not my lifetime.
Yeah.
It's not your lifetime. It's the actual item's lifetime. So if the tenant did anything to shorten that lifetime, and that's why it's so important to know if you have an oven, and my first question is always, if they say the oven broke or it's no longer heating up, or a plate's no longer. My first question is, how old is this item? And if this item has reached its lifetime, then it's unfortunate, but then it's going to be for the landlord's account.
But if it's a small maintenance, a fuse, I don't know much about ovens, but some element needs replacing. So again, the landlord would say, but the tenant's the one that's baking cookies, not me.
Yeah, but you provided the property with an item,
That
and it's
would-
not because of the tenant baking 50,000 cookies. If he just
Okay.
bakes cookies for his children, once a month, that's
We
what
need
the oven is
we need
used
to
for.
keep track of their baking.
Yeah, maybe he's selling it on the sideline for a side hustle. That's a different story,
Okay.
because your normal oven, your household oven, shouldn't be baking 50,000 cookies. But if the tenant didn't do anything an oven should be put on. You should be able to put food in an oven to cook it. But
Okay.
unless overused this item
Yeah.
by running it for hours on end from morning 8 o'clock till 5 o'clock in the afternoon, then you're going to overextend. You're going to shorten its lifetime.
And my next question is, it's a case study as well. Where do we draw the line when it comes to painting of the unit? The tenant enters into a property with the house rented, and then when they leave, there are small marks on the wall. Then the landlord says, I want it repainted.
Again, is it something that the tenant bumped against the walls, for instance, beds or pots or stuff like that? Then it's damage that the tenant caused. So then that part of the wall, you can't repaint the whole house and hold the tenant liable. But obviously, if you need to paint that wall, then that's the tenant's damages that he caused.
And you can't just do a little
and
smudge.
you can't do a smudge, because then it's not going to look right. And then that's unfortunate. But if you cause damage, and remember, the tenants must also bear in mind, while in tenancy, while in your 2-year period, if my child scratches, takes a Cokie and writes on your wall, I'm in the property, then there's a responsibility on you to fix it as a tenant.
Yeah.
Obviously, yeah.
You can't leave it until the exit inspection. And now that the landlord wants to use his supplier, now you're upset because his supplier might be more expensive than yours. Then you
Yeah.
should have done it
Yeah.
at that point in time.
That's a problem
When that
we face
happens.
always, yeah.
It happens that you carry a suitcase and you bump against the edge of a wall. It happens to all of us, or you move around
Yeah.
furniture, or whatever the case may be. But at that point, the tenant has the opportunity to fix it
True.
with whichever supplier, if he wants to go to Builders or Macro or whoever he wants to, where he wants to buy his supplies from, then he has the opportunity to fix it. If the landlord uses a specific contractor at the end, and that contractor might be more expensive or use a more expensive product or whatever, the landlord is entitled to do so. You had your opportunity as a tenant to fix it while you were in the property. You can't wait until the exit inspection and now debate and dispute what type of product I use or what type of rate I pay the laborers or whatever the case may be.
Yeah. But it's deep waters, this whole wear and tear. Maybe just for the benefit of everyone, if you can just give us a bit of a legal explanation, but also some examples on wear and tear, because this to me is the most unfortunate part of tenancy when it comes to deposit part, and we as the agents again are in the middle of it, because the tenants believe we holding their money, and it's not. It's the landlord that holds the money. At the same time, when we try and explain the reason to a landlord who maybe feels that the house has to be fully renovated by the tenant, then they feel we are just not on their side, which we shouldn't be in any case. We should be on the legal, lawful side and advise them accordingly. But because it's not specified, there's no document that says for paint you can claim this much, for carpets you can claim. One cigarette burn means replacing the whole carpet or replacing a portion. No, there's nothing. So often a landlord will say, no, this isn't wear and tear. I want the house the exact same condition. You tenant, 5 years ago. And the tenant says, but it's been 5 years.
And that's exactly going to be your test, is the age of the property, or how long has the tenant been in the property, and what, again, the lifespan is of a property.
Yeah.
or an item in a property. So, I mean, a lifespan of a cheaper curtain, for instance, if it's a fully furnished house,
Yeah.
is much less than a lifespan of a very expensive, double layer, whatever curtain.
Okay.
So you're going to have to, manage these expectations. And for a tenant to have lived in a property for 5 years, I assume those items were already in the property prior to the tenant moving in. So those items might be very well 6, 7, 8 years old, whatever they may already. When the tenant, the tenant only lived there for 5 years, but it's not like it was brand new the moment he stepped in. And that expectation also needs to be understood by the parties. And if you put in a carpet with a 5-year lifetime, but it was 3 years old when the tenant moved, that's going to be wear and tear. Because even though the tenant lived there for 5 years, by the second year, that carpet would have already reached its lifetime.
So even if it was burnt in one spot, the landlord cannot claim anything from them because the carpet is now so worn that it is ended its life?
You can negotiate and maybe, but it's a very slim argument, but the landlord say maybe you're going to have to get an expert, so you're going to have to get a flooring expert or a carpet expert or whatever in. But if he says, you probably would have gotten another year out of the carpet, for instance.
Yeah.
Having looked at it, the traffic that it handles, and the room's traffic also depends. I mean, there's much more traffic in bedrooms than in a spare room study that nobody uses. So those carpets are also going to look different. But with the burn mark, it can be, if you get the expert in and say, listen, you probably would have gotten another year out of the carpet, then you can say to the tenant, listen, there is damages. You're going to be liable for 30% or 20% or whatever. Because the landlord would in any event have to had the carpet repaired within a year's time.
Yeah.
But that's going to come down to negotiations. There's nothing in law that I can tell you it's going to be a 50-50. You're going to have to get that expert report in. You're going to have to get that, report back stating, listen, this carpet is 10 years old already. The fact that it lasted so long is great. Yes, unfortunately, there's now a burn mark. You might have gotten more out of the carpet, but other than that, it would have needed to replacement before placing another tenant in any event.
Yeah.
Then the timeline.
So everything is about negotiation. So
there's not a black and white.
It all goes to the agents again.
Yeah.
But on that note, you let's say you do your best and the landlord says, no, I'm keeping the whole deposit. And the tenant says, you're the worst agent on earth. You've kept my money. And you say, no, but the landlord is keeping your money. What is the recourse there? And does the agent then need to be in the rental housing tribunal once the tenant ends up taking the landlord there?
Not really. Depending on what your mandate is and what you agreed your responsibilities would be. I have an interesting one now that I think of it. It's not carpet related, but I'm going to tell you now. But no, remember that the property practitioner is acting as an agent on instruction from the landlord.
Yeah.
You can't do anything on that property without the landlord's instruction. You're just the middleman, so to speak.
Yeah.
All right. The contract is also not with you.
Yeah.
The contract is with the landlord, between the tenant and the landlord. You have a mandate with the landlord, but the tenant is not a party to that contract. That's you and the landlord. So if this situation happens and there's a dispute regarding the deposit, for instance, and the landlord says, I'm not paying back, then your obligation is to tell the tenant, listen, there is a dispute. The contract is between you and the landlord. The landlord instructed us or says he's not going to pay back the deposit. And the tenant's recourse then is go to the rental housing tribunal.
Okay.
Unless your mandate stipulates that you should appear on behalf of the landlord in all legal proceedings, which it shouldn't and it doesn't, I don't think it does, then the landlord and the tenant must sort it out. Obviously, if you want a relationship with your landlord, you obviously have a working relationship. If the landlord asks you to be in the tribunal, by all means do that. But you as an agent cannot be held personally liable or as an agency. So whatever is found, you're merely the representation in the tribunal.
Yeah.
So whatever is found, it's going to come back down to the landlord.
Okay, so I just need clarity on that. So what you're saying is, if we are taken to the rental tribunal,
It's not you, it's the landlord.
I mean, yeah, I mean,
Yeah.
if the landlord is taken to the rental tribunal, it's up to us to decide whether we appear on his behalf or he goes on his own.
Unless your mandate stipulates that you will attend to all, legal, the contract is not with you. You're not a party to the contract. So there's no, unless there's an allegation against the agency specifically.
Yes,
To
yes.
say you didn't manage the property well, or you didn't adhere to your obligations as an
Yes.
agent or an agency.
So maybe explain to us actually, what is the rental housing tribunal? What are they there for?
That is just it's a more informal setting than a court. They have the same jurisdictions in terms of monetary value, so they can make decisions up until the magistrate's court jurisdiction, which is 400,000. They cannot evict someone. The rental housing tribunal does not have the jurisdiction to evict someone. It is a service where you can't get a cost order, where in a legal perspective in the court, if the landlord issues summons against the tenant, for instance, for damages, it's now 100,000 rand damages, the deposit only covered 20,000, whatever the case, then the landlord can get a judgment to that effect and a cost order against the tenant in a litigation matter in a magistrate court. And you can actually get a warrant of execution if the tenant doesn't pay that amount that's awarded then, assuming then that the landlord proves his claim and all of that, then that cost order is also for the tenant's account. So then he sits with a judgment against his name, a formal court listing against his name for those damages. The rental housing tribunal can also make a order in terms of damages, but if you want to execute on that, you also need to take that order to your relevant magistrate court to actually be able to execute on that. So the jurisdiction of the magistrate court is much stronger, but it's also more expensive. So the idea behind the rental housing tribunal was exactly for that reason, that the parties can go there themselves and try and resolve this dispute, whatever it might be.
So the perception is it's a tenant complaint forum, but it's not. Am I right in saying
sides.
that? Yeah.
It's both sides. It can be landlord and tenant.
And
So
what
either
would
or.
so what would the landlord go there for, and what would the tenant go there for?
Well, I have a current situation where the landlord has a claim for the deposit and damages that occurred in the property. It's also a high-end property, so we are looking at the 50,000 rand odd. It was leather couches and stuff like that. That the tenant's dog actually ripped apart, and he tried to fix it, not with the correct leather. Long story short. So the tenant says no, he's not going to fix all of that. And there was an early cancellation as well of the lease agreement within this whole story. So the landlord actually issued a letter of demand to the tenant for these damages. The tenant says, I'm not paying. And he put in a counterclaim. So he said, yeah, but you owe me this, this, and this. All right. So the landlord actually went to the rental housing tribunal. It's not finalized yet, so I can't tell you what the outcome was, unfortunately. Maybe in our next session I will be able to. But the landlord took the tenant to the rental housing tribunal and says, listen, this is the damages. I'm claiming this from you. It's above the deposit that I'm holding. The tenant is bringing his counterclaim, so we'll have to wait and see what the tribunal does with that. But the landlord instituted this action.
Right.
Yeah.
Okay.
And there's a lot of things that the landlord, if the tenant, doesn't adhere to his obligations, or it's mostly damages. It's mostly damages and arrear rentals that they do keep busy with. From the other side, from the tenant side, it might be a bit more, illegal eviction, and that's the actual example, or the story I want to tell you guys. Also, a situation where the landlord and the tenant didn't get along. Okay, so let's just start there. But for personal reasons, whatever, the landlord literally, against all advice of his property practitioner, we were representing the property practitioner, thank heavens, but against all advice, he literally took a few guys, went to the property and helped the tenant out, and then changed the locks, okay, which is obviously an illegal eviction by all means. The contract was already cancelled at that point in time, so the landlord really just should have started with the eviction application.
Yes.
We were already there, but he refused. So he took his own thing. The tenant went to the rental housing tribunal, obviously for illegal eviction, which I agree with. It totally was an illegal eviction.
Yes.
Yes.
And then went to the police to lay a claim for harassment and trespassing and all of that. So
Because he physically was removed.
he was physically removed. She and her
Yeah.
children. I think there were 2 kids also involved.
Oh.
I immediately told the property practitioner, you're cancelling this mandate with this landlord. You obviously
Yeah.
don't want to deal with someone like this. And you don't want to have that reputation, on your name if it wasn't anything you did. So all of that was done. So, they are still proceeding this. Actually, the agency went on Wednesday. They were at the tribunal to tell their story and say, listen, we had nothing to do with this. It was the
Yes.
landlord on his own accord that actually...
Were they called or did they just volunteer to?
They were called.
Okay.
Unfortunately, their contract wasn't correctly drafted, and they made themselves a party to the contract, which they shouldn't have done.
Okay.
But that being said, as soon as we, advised the rental housing tribunal accordingly and said, listen, you're acting against the wrong party here, they were happy to let them go
Okay.
with that explanation. But the landlord is in big trouble. The landlord
Yeah.
is in big trouble.
Yeah, that was a wrong
We're
move.
dealing with this right now. We have a tenant that's been ducking and diving and dodging this whole, the usual last month where they don't pay rent, thinking you're just going to hold my deposit against the rent. But they're also completely unavailable for us to show the property to other potential because it is the last month. He's given notice. We know he's going to move out end of this month, but we need to find another tenant. And the landlord said, well, you've asked him several times, put it in writing and then just go and, show the property. And I said, it's not going to happen. No.
doesn't work
The
like
answer
that.
is no. Unless the tenant has agreed, we're not walking into the property.
What you should then again, and
Yeah.
I love the TPN lease, it actually makes provision for that. So if in the TPN lease it states that in the last, you can obviously, the landlord may sell the property at any time, and
Yes.
obviously then the tenant needs to allow viewings and so
Yes.
forth. But it does state that the tenant needs to allow access to the property for it to be showed to prospective tenants. It's in
Yeah.
the lease agreement. Again, if he doesn't, reasonableness, you can't phone him this morning asking for this afternoon. He's in breach of contract.
Yes.
And then you send out a letter of demand, giving him 20. Now it sounds overkill, but then giving him 20 business days to actually allow you access. Now in the last month, like I said, it might now not work out, but do the
Yeah.
letter of demand.
Yeah.
Do it in any event. Because if that 20 business days lapses, and remember, 20 business days doesn't have to start from the beginning of the month.
Sure.
So
Anytime.
you can, it's 20 business days from wherever. So if that 20 business days lapses on the 25th of the month, for instance,
Yeah.
you can cancel that lease immediately. So then he needs to move out by the 25th of the month. And the tenant also needs to understand that. He can't keep the property hostage, so to speak, and not allow access.
But again, the person that is ignoring you so far is not going to move out because they know there's nothing you can do. Surely the landlord still cannot walk in.
He cannot walk in, but at least
Yeah.
if you've done the letter of demand, you can cancel the lease.
You've
and
gone
then,
through the process.
then
yeah.
you are in illegal occupation.
Yes. Okay.
And that changes it a bit
Okay.
because then you can start with the eviction process. Now, again, we know he's going to move out by the end of the month,
Yes.
but then you have a much stronger right,
Sure.
to address the issue. Then sit with a property that you cannot, and you're just asking nicely, and they don't
Yeah.
adhere to you.
Yeah. Yeah.
So,
But
yeah.
I mean, it's quite an interesting, and you guys must deal with a lot of those. But it gets tough, and landlords get desperate as well. They've got bonds to pay,
Of
their levy
course.
accounts, and rates and taxes, and all that. So, in your current experience, how long does it take if one is to go? I mean, I've only ever dealt with one eviction. It was my own property that I rented many years ago, and that's when I learned the importance of proper due diligence and background checks. But sometimes they do evade that, and you have the so-called, it's almost like career tenants,
Yeah, they are.
eviction tenants. I don't know what they're called, but they know that it takes a certain amount of time
It's
for the
repeat
eviction.
offenders.
Repeat offenders.
Yeah,
Obviously
yeah.
they're experienced.
And that's, it's a very good question. But again, it comes down to you need to send out that letter of demand for whatever breach it is. And it sounds now petty,
Yeah.
but it really isn't, because you are mitigating your risk. You're mitigating the damages that the landlord can incur. So if, let's use the viewing of the property example again. In the lease, it states 3 months prior to that lease coming to an end. Obviously, if you're then going to tell the full due process, this tenant's not going to be, kept on, and the lease will terminate and he needs to move out. That's why there's a 3-month period. If you realize by the first of the 3 months that this guy's not going to give you access, then you do that letter of demand. Ordering or requesting access as per the lease agreement. And then if he doesn't adhere to that, then you cancel that lease agreement. Yes, we know the lease agreement is coming to an end in any event.
Yeah.
But you don't want to sit with a tenant in the property, not being able to show it to other prospective tenants. He's hijacking or holding the property hostage or whatever the case may be. Then that process is much quicker and you save time come the eviction.
Yeah.
Because remember, before an eviction can be started, a letter of demand has to be done and the lease has to be cancelled. If either of those steps are not done, that has to be done first. So then you delay your own process. So if you then wait until the end of the month without showings, without anything, or without the rent being paid, and then only you do the letter of demand, that's when your timeline then starts. But then you have to give them 20 business days. And then you can cancel the lease. And then that delays the process. So if you've done that letter of demand, the first instance that he didn't pay the rent on time, then you shorten that time frame and time period. The evictions at this point in time, depending on your courts, Pretoria Court, for instance, is between 3 and 6 months. But it's going to be court dependent. How busy the court rolls are, how many evictions there are. But you can more or less work on a 3 to 6 months. But now if they promise to pay for 3 months, then your period only starts 3 months later.
Yeah.
You see, so if you rather send that letter of demand, if the tenant then, for instance, pays or allows access, then you say thank you. And that's the end of it. It's no hard feelings. I'm not mad at you. It's not personal.
Yeah.
But at least you followed the correct procedure and mitigated the risk as far as you could.
Yeah, I think the not personal part is where often a lot of times, parties just forget about that. It's actually, it's a product, that the tenants, it's like a hotel, and you pay for a service, and, it shouldn't, personal opinions and relationships. And that's why it's sometimes better for tenants and landlords not to really become too close, or because as much as they can be buddies, suddenly things can go sour. And then too much emotion gets involved.
Yeah, we really need to take out the emotion. And that's what I always say. I'm not scared to send out a letter of demand. I'd rather say, thank you for paying. You can ignore the letter of demand going forward than not having sent it out. And then you sit with that problem. No, but now I'm going to pay next week. And now I'm going to pay at the end of the month. And now, you sit with that problem.
And then what is this thing, beneficial occupation? You guys have it in your lease, and people always ask, what is it after 2 years or 3 years, or if it's a long tenancy? Yeah.
The beneficial occupation, that comes down to your usage of the property. That has a lot to do with the Consumer Protection Act. It has to be a benefit to you. In the Consumer Protection Act, there are certain contracts that are limited to time periods. So you can't have a cell phone contract for longer than 3 years, or whatever the product might be. So there's a limit on certain products.
Right.
But as long as you living in the property is beneficial to you as tenant, this lease agreement may remain in place. So there's no limit on a lease agreement. There was a misconception that lease agreements can only be 24 months.
Yes.
It's not true. Because there can be beneficial occupation after that. You can live there for 3 years or 4 years, unless the property is demolished for some reason.
Yeah.
But it can be a benefit to you for a longer period. So that's what that's about. It's in line with the Consumer Protection Act. And then, because certain contracts are only allowed a certain period of time. You cannot extend those contracts.
So you can sign a contract for 3 years?
You can.
Okay.
You can sign a contract for 3 years. There's items that you can't sign a consumer protection, in terms of the Consumer Protection Act, other items, that is not allowed to be for a longer period of time. But that does not apply to the rentals. You can do a lease agreement for 3 years.
Okay, because some tenants want to sign a longer lease because they don't want the lease to be increased. So immediately we go in the second year and we tell them your lease is now increasing, and then they freak, no, but I signed for 2 years.
Look, those stipulations needs to be in the contract. If there's going to be an increase after year 1, it has to be in the contract. So you're going to have to show and advise them, whether you sign for 5 years, it doesn't really matter. After every year, there is going to be a 10% increase, for instance. And they need to be aware of that. So it doesn't matter the period of time that they sign the contract for. If increases are applicable, it has to be stipulated in your contract. The only thing, with a longer period of time, obviously you want a tenant for a longer period of time. You want to have that relationship. You don't get married with the intention to get divorced. That's not the idea behind it. So you want to have this perfectly working relationship between your landlord and your tenant. You want that. That's what everybody would want. So if it is only a 2-year contract, for instance, we recommend that then there will be one renewal after that 2-year period. But then if they stay on longer, not to merely do another renewal, but do a whole new contract.
Okay.
And the reason for that is legislation might change.
Right.
So now you sit with a contract that's dated or starts from whatever, and then in 2014, for instance, some legislation changed. But your contract still refers to the prior legislation. Or, when the Estate Agencies Affairs Board changed to the PPRA, there was a lot of implications there.
Yeah.
A mandatory disclosure form wasn't necessary, now it is. So that's why we say this. It's not an obligation in law that you have to do a contract every 2 years. You can do the addendums, but then you must just bear in mind that if something changes in legislation, or situations between the parties, or whatever the case may be, or the forums that you can actually address, that might have an effect on your contract. So that's why we always say the 2 years is fine, one renewal, and then a new contract. It's going to have the same terms, I know that, but if there is anything that needs to be
At least
changed,
you're covered.
then you are covered, exactly.
And that mandatory disclosure, it's been now a while since it's been in place. But still, we find, wasn't it just after COVID actually? Or I could be wrong. I think it was implemented after COVID. But either way, it's been a couple of years, but people are not familiar with it still. But also the one that is the mandatory one prescribed is quite superficial, really. It's in fact, it's items that people generally don't care as much about as they would if their underfloor heating's working, for example. So what is the expectation there? First of all, landlords don't even understand, why must I fill it? I've been living overseas for 20 years. I can't say anything because I don't know the property. I haven't seen my property. So how do you guys navigate this?
Yeah, look, you as an agent will then obviously complete it on their behalf. The mandatory disclosure, you can't accept a mandate as a property practitioner without that mandatory disclosure form, because that's going to have personal implications on you as a property practitioner. So, but you can sign it on behalf, you can fill it in on behalf of the landlord. There's a lot of overseas landlords, so that is not an issue at all.
But doesn't this put the responsibility on us to know whether there is foundational issues, which we're not aware of?
There is luckily the option unaware or unknown. And that's what you tick then. The mandatory disclosure form by no means confirms that anything's going to be changed or anything is going to be fixed.
Yeah.
I mean, if we know there's a small wall and you know there's a small crack in the wall, then that's it. It's not a affirmation by the landlord that he's going to have it fixed. It's just a condition of the property as you receive it.
Mm.
Because unfortunately, there was a lot of issues with properties being sold footstewards. And that's where the mandatory disclosure form actually came from, is from the
Yes.
buyer-seller situation. And then, 6 months down the line, you realize there's a big problem with this property. And there was no recourse.
Mm.
So that's why they brought in the mandatory disclosure form to say, listen, I undertake, or I know, I don't want to say under oath, but basically confirm this is the condition of the property.
Yeah.
By no means is an admission that I'm going to fix it. If the wall is cracked, the wall is cracked. Then I note it as such, and that's it. And that's the end of the story. But then both parties are clear as to the condition of the property. If it is then found that something was hidden and the landlord knew about it, that might be a whole different argument and a whole different problem. But if you act on behalf of the landlord and you fill it in relating to your inspection, there's a few items that you might now need to check extra in this instance, but you can do it on behalf of the landlord, and that's just a condition form. It's just literally, this is the condition of the property, this is what's working, this is what I'm aware of. Otherwise, you sit with a situation a month down the line, there's structural damage that the landlord might have known about, but he just didn't disclose. But that's a different fight. That's a whole different fight, how to prove that and disprove that. But it's merely, people should not be intimidated by the document as such. It's really a condition report. And I undertake that I'm giving you what I'm saying I'm giving you.
And would you advise then, having experienced various cases, that additional page is added just with a little bit more detail around actual issues inside? I don't know, the kitchen cupboards are a bit loose, or something along those lines, because the prescribed mandatory disclosure is very much structural roof.
It's very structural,
and it ends there.
Yeah.
But if I wanted to say, the certain, taps inside, or the underfloor heating's not working, or whatever, would you advise to have another page, or would you just loosely write? Because my issue here is that if you don't have a structure, the landlord won't necessarily remember on the day of completing it if he's not prompted to say, what about the underfloor heating? And that open space that they give on the mandatory disclosure, you might not remember of everything, and then you write nothing there. And as a landlord, I think it is better that they do think about the condition.
You can't write too much.
Yeah.
Nothing prohibits you from writing too much. And even in your inspections, if there is a cupboard that is a bit loose, it's not life-threatening, it's not going to fall on your head.
Yeah.
It's not really, it doesn't make a difference to anyone's life at this point in time. The problem is, now the tenant lives there for a year, now the thing falls off. All right. Now the landlord says, but no, look, there was nothing of this loose cupboard in the beginning. And the tenant says, but it was loose when I was here.
Yes.
Now, how do you prove it? Had you written it there, then we could have said, okay, it was a bit loose, it now fell off. So there might be a contributory negligent part on the tenant, or it might be the fair wear and tear. But then it actually assists you in actually determining what caused the damage, or, what recourse you have. Is it going to be, both parties 50-50, or, should it have been repaired? That actually clears the air a bit.
Okay.
So I would rather have everything that you can think of, and especially jacuzzi's not working and underfloor heating not working and stuff like that, and the fireplace without the chimney.
There's another property that we sold some time back, a few years ago. The whole ceiling fell off. Summerfields, the whole ceiling in the living area fell off. But at that time, the mandatory form was not there.
Yeah.
So they called and they were screaming at me. I was like, I don't know.
Yeah.
No, the seller lied. I said, I don't think so, because we were together.
They probably didn't know about the workmanship.
Yes, they probably didn't know anything.
And it's even, I've even realized it in our field, with the conveyancing and so forth.
You guys also do conveyancing, right?
Yes, we do conveyancing. But then the conveyancer gets the brunt of it. He's never even been in the property. He doesn't even know what the property looks like, and he gets shouted at by the buyer and says, "Yeah, but your seller didn't confirm this, and it's your fault."
Yeah.
And that's again the expectation. And there you guys are the middleman between the seller and the conveyancer. The conveyancer also can't comment on anything. He was never at the property. He doesn't have a clue what the property is like. And then the sellers and the buyers are screaming at him or her, for the condition of the property. So, but it is, I think it's again the expectation and what I thought I'd buy and what I did buy, and that's what I'm saying.
What I ordered and what I got.
Yes,
This is what I got.
you ordered, you saw this nice picture, and then you got this little thingy.
Yeah, it's like those online shopping sites.
Exactly. So it's the same thing, and I think that the mandatory disclosure form, look, it can be, I think there's a lot of scope for it to still be made better.
I could
more
add 3
detailed.
pages
Exactly.
easily.
There's a lot of scope for that, but
Yeah.
it makes sense. It makes sense, and it makes sense to how it helps the relationship between the parties. So, I mean, rather write too much, and rather, even in your inspections, if there's any ingoing inspection, write that there is a little chip on this table. Then
So we do those inspections, and our inspections are 30, 40 pages on average, with a ton of photos. And this is now an interesting one, because you do your 30-page inspection, and the tenant will say, oh, well, this is now your action list, because now everything on your inspection has to be actioned. Again, what is the expectation on the inspection? If something is not working, yes, presumably it must be working. But if there's a cracked tile or a chipped wall, what is the expectation?
the expectation is what will the landlord fix before the tenant takes occupation? So obviously, if there's what can we use? Some of the electricity.
Fallen ceiling.
A fallen ceiling. Okay. So there has to be a ceiling before the tenant takes occupation.
Right.
So that is something that the landlord will need to address. No tenant will in any event sign a lease agreement with a ceiling on the floor. So there are items that the landlord will then say, this I will repair before you move in, or even within a month of you moving in.
Yeah.
But that has to be stipulated. If it's a cracked tile, but it's not lifting, it's just cracked.
Yeah.
It's doing nothing else but cracked.
Yeah.
There's no obligation on the landlord to fix it. And there can be no expectation on the tenant to fix it, unless it now suddenly lifts and you can cut yourself.
Sure.
That's a total different story. But I mean, if there's a scratch on a wall, there's no obligation at that point in time. You accept the property as you see it, unless it's life-threatening or causes damages to your health or your use of the property. I mean, you can't have a door that can't open.
Right.
Or a window that can't open. I mean, that's stuff that needs to be addressed. Or a fireplace without a chimney. That's stuff that needs to be addressed.
Yeah.
But small things that doesn't really affect the use of the property, an inspection does not confirm that it will be fixed.
Yeah. It's
And that's that's just a record of the condition of the property.
yeah.
Unless it's something that the landlord then agrees, I will have item A, B, and C fixed within 6 months before you move in, but that's going to be a special condition then.
And then on that note, if a tenant's about to move in, it is highly advisable that they are present at that inspection.
Yes, definitely.
Because we're finding it at the end of the lease so many times. The landlord will say, but the place was brand spanking new. The tenant says, absolutely not. This tile was always, or we've had recently a scissor stone top in the kitchen, and the whole edge is broken off. Now I've lived a long life, and I've had many kitchens. I've never seen the whole edge come off.
No.
That's proper pressure,
Yeah, no, you
And the tenant said, no, it just happened.
Oh.
And I said, no, this is a very heavy pot that came down with force and whatever. And the stuff like that. But unless they were present at the inspection, entry and exit, you find the fights then.
Yeah, it's very important that both parties, and I say both parties because the Rental Housing Act refers to landlord and tenant, but obviously you as representatives of the landlord then represents the landlord, but both parties need to be present at the inspection, so that they are clear at what they are renting and what is happening around them, what it looks like, what they can deal with or not deal with. So it's very important. The Act even goes so far, if either party is not present, if the tenant is, for instance, not present at an exit inspection, he accepts the condition of the property as is. if a landlord isn't present at the exit inspection, he doesn't have a claim on the deposit. He needs to pay the deposit back.
And
So-
when do these inspections need to take place? Because that's another thing
Yeah.
now.
That's what I
that
wanted to
happens.
ask. So
Yeah.
you're saying when before the tenant takes occupation, they're supposed to be present for the inspection.
Yes, I would recommend it.
The day of moving?
Well,
Oh.
it depends on the timeline. It's going to be very difficult
Yeah.
because some tenants
They
might move in a
work.
day before, or they so it's going to be difficult. But I mean, if a tenant, if you've signed that lease agreement or you're about to sign that lease agreement, and that inspection is done, rather have the tenant there. If it's really not possible to have the tenant there, then the Act makes provision. Obviously, you do your inspection in any event.
Yeah.
You provide the tenant with that.
Pictures, yes.
You provide the tenant with that inspection. The tenant then has 7 days in the Act, as per the Act,
To report,
if
yes,
there's
obviously.
anything else.
Yes.
Mm.
Or if he then disagrees with any of your findings. So say, for instance, he now walks through the property and you noted a scratch or no scratch,
Yes.
and he sees a scratch, then he needs to report that.
Mm.
So he needs to be in possession of that inspection report.
Mm-hmm.
So it's not practical to have the tenant always present. And even with the exit inspection, it says 3 days prior to
The
termination
exit.
of the lease. That's not always practical. Having regard, this Act dates from 1998-99. So, I mean, it's also due for an upgrade, probably, in a lot of things. Because, like I say, it mentions landlord and tenant. It says nothing about property practitioner.
Yeah.
So, but that being said, so it's not practical 3 days before because the tenant's property would still be in the property.
Yes.
Mm.
There's going to be pots and beds and
Yeah.
couches
You
and
can't
whatever. You can't
see.
see
Yeah.
everywhere.
Yeah.
All right. So the Act and the application of that 3 days prior is not as strict.
Okay.
So you can literally on the last day that the tenant literally moves out,
And do the inspection.
you do the inspection and,
And
have
then,
the tenant there. Yes.
since we are representatives of the landlord, it's fine if the landlord is not there,
Yes,
as long as
yeah,
we are
as
there.
long as you are there, yeah.
Mm.
So we need to be present
Or our inspector. Yeah.
with our
And if you use a third,
Yes.
yeah,
if we use a third party, it's
Perfect.
fine.
Perfect.
Yeah.
Oh,
Yeah.
okay, all right.
Yeah.
No, because I'm just
Yeah.
thinking.
But for the purposes of the tenant, then they need to look at that inspection. They
Mm.
can't say a year or 2 years later, well, I never opened it, therefore
no.
all of that stuff wasn't actually, I disagree.
Mm.
Yeah.
It's that post that you have lying in the post box that
Yes.
no. Nobody,
Yeah.
if there's a fine in there or if there's a,
Yes.
a letter of demand in there, you can't say, well, I never opened it, sorry.
Yeah.
So no, they have to have, there's certain responsibilities on them.
Yeah.
And that's why the Act gives it, because they know it's not going to be practical to be there, they're working, or they only move in by 4 or whatever the case may be.
Yeah.
But that's why they have the 7 days then thereafter. But they have to be in possession of that inspection then,
Yes.
to be able to know what to check and where
Sure.
to check. And
Yeah.
and you can tell them, listen, if you disagree or if you see something else, or if I miss something, I mean, you might also, your inspector might also miss something. It's
Sure.
human. That it be reported.
Yeah. And another one, grace period. Is there such a thing?
No. There is no such thing.
It's not in your lease. I looked.
No, it's not. It will not be in our list. And it's actually on. If you have a look at the TPN website as well, they've got a few frequently asked questions, and one of their frequently asked questions is, what is a grace period? There's no such thing. If your lease stipulates that the rent has to be in the property practitioner's account by the 1st of the month, that's it.
That's it.
If it's not there by the 2nd, then you are in breach of your lease agreement. All right. There's no grace period with I'm going to pay in a week's time.
On the
or
3rd.
On the
Or
3rd.
money's coming.
Money's coming. There's no such thing. Letter of demand. And then rather say, well, thank you for your payment if it was then received. Otherwise, then you cancel the lease agreement.
Okay.
So, and that's the same thing with any of the obligations. If there's an obligation on the tenant, yeah, but I'll fix it at the end of the month or something like that. There is really no grace period. There shouldn't be, for obvious reasons, because once you actually allow something like that, it's kind of
becomes the new boundary.
becomes the new boundary. Then I'm going to start
Yeah.
paying by the 10th, and then I'm going to start paying by the 15th, and then and then you have a risk in that
Yeah.
regard. So no, definitely not. And even if you look at the evictions and where you cancel a lease agreement, obviously the letter of demand stipulates it has to be 20 business days, the letter of demand, or then 7 days if it's a month to month. But once that lease agreement is cancelled, you can actually, the tenant needs to vacate immediately, which is not, again, practical.
But
and
they
that's-
they knew it's coming.
they knew it's coming, so you can actually demand that they vacate the property immediately. The courts, however, have a distinction between certain people that live in the property. So if you are disabled or you have minor children or there's elderly persons on the property, even with an eviction in court, there's no such thing that these people can't be evicted. They can and they will. The court just gives them a longer period of time to vacate the property.
Okay.
So where they would, a student that's perfectly capable to look after himself will give a week to 2 weeks to vacate. They will give a elderly person a month to vacate, for instance.
Right.
But it doesn't come down to a grace period. It has nothing to do with a grace period.
It's just
It's
a bit
just
of leniency.
reasonableness. Because
Yeah.
it's more reasonable for an elder person. It's more difficult for him to find a home. He can't just move in on the 5th
Yeah.
floor,
Yeah.
where a young 24-year-old male can
Yeah.
run up the stairs, no problem. And that should be distinguished from actually grace period. That's just reasonableness, and that's why I also started my reasonable and your reasonable might be totally
Yeah.
different.
Yeah.
And that's what the courts consider. But it's not a grace period. No, there's no such thing.
Yeah. And returning of deposits, what can a tenant expect? They left on the 30th of June. When is their deposit due back legally by the landlord? So the landlord doesn't withhold it unnecessarily.
Look, it's gonna depend on the repairs that obviously need to be done.
If it's in perfect condition,
Perfect condition, 7 days. If there's repairs to be done, 14 days of repairs.
okay.
All right. But then also you must also reasonableness, and it really sounds like I only have one word in my vocabulary today. But over a December period, for instance, there's a lot of public holidays.
Yeah.
There's a lot of, you might not be able to do the inspection on the 1st of January.
Yeah.
Because everybody's on leave and whatever the case may be. But that needs to be addressed and that needs to be discussed between the parties.
Yeah.
So that expectation is not created that I'm going to get my deposit back by the 7th of Jan.
Yeah.
But I mean, the 1st and the 2nd usually is holidays.
Okay.
But that needs to be addressed. If you have a lease that ends end of December, then you make sure your tenant is very well aware that the inspection is not going to happen on the 1st of January.
Okay.
You can, obviously, if the inspector is available and,
Yes.
willing and whatever. But, I mean, again, reasonableness.
Mm.
You don't expect me to work on Christmas Day, so why must I expect you to work on Christmas Day? So stuff like that, you just have to, adhere to. But other than that, 7 days, if there's no damages, 14 days of repairs.
Okay. Okay.
Okay. No, reasonable.
So how long have you been doing this for?
Well, I've been admitted for quite some time. This is a newer field.
Okay.
So I've been admitted since 2008 as an attorney, but this is now a newer field, about a year and a half that I've been
And how are
doing
you
exclusively this.
Yeah.
It's actually quite interesting, and the scenarios you find every day, it actually, I didn't at first believe things like this happened. Because you're like, what?
Obviously, yeah.
But no, it's actually quite interesting, and a lot of the times it's really, I think it becomes problematic because of the emotions involved.
Yes.
I think for me, I'm removed from being personal to either party, so I think
Yeah.
it's a bit easier for me because I just apply the law and what you should and should not be doing. I think it's much more difficult for you guys in the middle.
Yeah.
In these fights, but no, I find it quite interesting, and I enjoy it. It's really a nice environment. It's overall really not a negative environment. I've been at previous firms and in previous aspects of the law. That's really a negative environment that you really don't want to be in. But no, this is actually quite interesting, and a lot of the people that I meet, are very. I don't know. I like the experience. I like the change of scenery. So it's actually I'm loving it. Yeah,
Meeting different people
meeting
every
different
day.
people. Yeah.
And do you guys represent tenants, landlords, agents, all parties?
We focus on the agencies and then obviously the landlords, as
Okay.
you are then, represented. Well, you represent the landlord.
Okay.
There's a very few that we represent the tenants, purely for the reason is we represent agents. So you don't want to sit with a conflict of interest.
Okay.
So I can't act against one of your tenants if I know you are the agent involved, and in the same
Okay.
breath, I advise you on different matters.
Yes.
It doesn't even have to be the same matter, but we try to keep that relationship professional and apart. So we focus more on the landlords and the agents and the property practitioners and the agencies and so forth. But I mean, if there's a tenant with an issue and we don't have a conflict of interest, then there's no problem in representing them as well. We also have a dedicated rental housing tribunal department that literally deals with the rental housing tribunal. And then we also have the conveyancing, some wills and estates. So we have a
Okay.
whole spectrum, and a lot can flow from properties that we don't even
Yes.
realize. We have a situation where a landlord passed away last week, and now we sit with a deceased estate. So there's a lot of things that can happen from properties. And I always enjoyed property and. You watch all those shows on these TV.
We
with
do,
the
but that's not the
renovating-
reality.
It's not reality. That you realize now, but now I know at least where the love of properties come from.
Yeah, true. But I'm not envying your rental housing tribunal department, because
No,
that
no, me
can't be a
neither.
pleasant
No,
experience.
me neither.
And between commercial and private, what is the situation there? Is it obviously residential and commercial are different things?
Yeah. Look, we have a lot of residential evictions. We do have commercial evictions, but then there's more of a reputational risk for the parties involved. So they don't really like, if it's big companies with big names.
Okay.
They don't really want to, but they did not pay their rent, so they kind of get sorted or settled, where, the tenants, it's not like they have a reputational risk. Nobody knows who they are, what they do for a living or whatever.
Yeah.
So we do find the commercial. There is commercial evictions. It's not. I've done one in a mall. It was actually a spa.
Sure.
That had to be evicted from a mall in, I think, Krugersdorp. But so it happens. But it
Okay.
in my opinion or in my experience, it's much less than the residential evictions.
Because
But
it's business, no emotion.
it's business,
Yeah.
yes,
Yeah.
yes, exactly. It's business, and there's
Okay.
no emotion involved, and there's this reputational risk. You don't want to kind of
Yeah.
have this bad flag on your name if
True.
you are a company.
Okay.
Yeah.
Did you cover your agenda?
Yeah,
Did
no,
you-
I did. No, I did. The
Good
tribunal.
for now.
Yeah, no, I'm good. I'm now settled, so I'm not
I'll
scared
give you
of.
our rental or the tribunal department's number, then you can.
Please, you should. Please, you should. But I'm not scared now.
It's
I
your,
know.
fir-
There you
it's your
go.
first.
Yeah, it's my first.
Yeah,
so
I've
Yeah.
also never.
yeah,
Now,
we've
unless-
never been actually.
we
Unless
try
you
to
were
mitigate.
negligent, then you should
Yeah.
be fine.
Yeah, for sure, for sure. Yeah.
No, you've answered everything, all the concerns. So let's see how it goes. But when we get stuck, we know where to come.
Thank you very much.
And that's the main thing, is really just follow the law rather, and
Mm.
rather take a little bit longer
Yes,
and
but
no
then it's
emotion.
done correctly. Yeah.
Yeah.
No emotion. Yeah.
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 Be reasonable.
Reasonable.
Reasonableness
If
is the word.
if anything else, be reasonable.
Thank you so much for coming.
Thank you. It was
And
fun.
Thank you
Yeah.
for your time.
And next time we'll have even more. Hey.
Definitely.
Looking
yes,
forward to it.
Okay,
Looking forward
thanks.
to it.
Because we've got a huge rental book, so problems come every day.
Please keep them coming. Keeps my life interesting.
Yeah.
Thanks a lot.
Thanks so
Thank you
much,
so
guys.
much.
Appreciate it.
Alright.
Thanks.